Hi, y'all, and welcome to tonight's live stream. Well, the Commonwealth rested today in the Karen Read case, and they ended just like they began with some critical words from Karen Read herself, things she told the media. You're going to hear those words tonight. This was one of the most important days of trial, and it's not because there was any bombshell, anything particular, but because the prosecution put everything it had behind one witness. That was the witness on the stand today, has been on the stand. This is now the third day, Dr. Welcher. He's the reconstructionist brought in to convince the jury that it's possible that Karen Read hit John O'Keefe with her car. Of course, Karen Read says that's not possible. Instead, her boyfriend, John O'Keefe, was murdered inside the home of 34 Fairview, or at least by people inside the home, and then his body was dumped beside the road. Now, I know that people have very strong feelings about this case. For any of us, it can be hard to hear things that are different from what we believe or what we think. But I do want to make this pledge to you every night on this channel. I am going to try to give you my very best and my very most honest take. I've got a Harvard Law degree and 30 years of trial experience, and none of that does you any good if I'm not willing to be straight with you. So tonight, I'm going to walk you through what the jury actually saw, what they actually heard, and how Dr. Welcher had held up on cross-examination, and what this may mean for the defense as we move forward. So special shout out to the first five in tonight's chat: Michelle B., Michael Lalonde, Angel LaFawn, Loretta Powell, and Connie Presley. Be sure to hit that like button and the subscribe button. We would love to have you come back for more. We are getting very close to 200,000 and would love your help to help us get there. All right. So we started the day, as many trial days start, with an argument, the two sides arguing. Now, here's what the defense was wanting and what they asked for. They wanted to cross-examine Dr. Welcher with a couple of pieces of information that they thought would really help them. Now, in the last trial, this is, of course, a retrial of Karen Read, not the first one. The jury hung in the first trial, and now we have the second trial. In that first trial, the Commonwealth did not have this polished professional expert, Dr. Welcher. Instead, they had a local Trooper Paul, who did the reconstruction. And during the cross-examination at the trial number one, Trooper Paul walked into a buzzsaw. It was a disaster. He was not trained. He was not up to it. The defense would love to use Trooper Paul's report to cross-examine Dr. Welcher, to say, hey, you have different ideas, or you ignored things, or this is what he said. Among other things, Trooper Paul got really twisted around and claimed that a key event ended after the Commonwealth already had possession of Karen Read's car. Now, the Commonwealth says that Karen Read's Lexus registered an event, they're calling it 1162-2, and that it was during that event sequence that Karen Read backed into John O'Keefe and laid him out in the yard there at 34 Fairview. But Trooper Paul, had this event happening after the Commonwealth had impounded Karen Read's car. The event ended afterwards. And that wouldn't really make sense. So the defense would love to use this with Dr. Welcher to cross-examine him. So here is the argument made by Karen Read's lawyer, Alessi, who was up all day today.
Commonwealth knows Trooper Paul and Dr. Scorti-Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162-2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc.
So what the defense also would like to use, not just that, not just Trooper Paul, but they also wanted to use an opinion from another Commonwealth expert, an expert the Commonwealth did not like, their very own medical examiner, and they put her up, but they do not like what she had to say. Dr. Scorty Bellows said that during her examination of John O'Keefe's body, she concluded that there was no way to determine how he had been killed. It was undetermined, and that she did not think his injuries were consistent with a car accident. So here's the argument about why they want to cross-examine Dr. Welcher with that.
Medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to, respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries.
They are trying to pit the inadmissible opinion of a non-testifying witness.
Okay, so the Commonwealth's response is that the fact that someone else has said something, another expert in the first trial or earlier in the trial, is not the same thing as giving them permission to cross-examine someone else about it. Here is what the Commonwealth argued. Those first words that I've already played by accident were, they're trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness.
Against a testifying witness.
They have
asked Dr. Scorty Bellows what her opinion is, and although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or a mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful. They take it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welch these questions, which he did not rely on. We had a voir dire, he was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scorty Bellows. It is that simple.
Now, the judge ruled easily with the Commonwealth in this particular case. She didn't even really give it long thought. She was like, okay, last argument. No, I am not ruling for that. I'm not going to allow you to use Trooper Paul's report from the first trial. I think that was a pretty easy call. I think she definitely should not have done that. I mean, I think she made the right choice on that one. He is not a testifying expert here, and the Commonwealth went to great lengths to make sure that there was no reliance on what he had done. The arguments were pretty minor as far as what was used, that maybe there was an aerial photo that he had used that made its way into Dr. Welcher's report. Overall, they were relatively small things. And so I think the judge made the right call there. Now, the Scorty Bellows issue is a little bit harder. Scorty Bellows testified, and the judge allowed her to say that the cause of death was undetermined. I cannot recall whether she allowed her to say that she believed it was inconsistent with motor vehicle accident. But typically, you are allowed to ask one expert about what another expert has said if it is in their exact realm of testimony. And I think the argument here from the prosecution was that it would not be. The judge easily finding that. She didn't even give it a lot of debate. She may have thought about it overnight, but she quickly ruled for it. So I wanted to go through and I'll go ahead and pull out for just a minute. I wanted to go through what some of the what was said in terms of how the defense went about cross-examining this witness. As I said yesterday, this was an excellent witness. He's very polished. He knows how to testify in a court, and he knows how not to answer a question, how to throw in a lot of words around there and to keep from answering the question. It is very difficult to cross-examine a witness like this. And I am in full sympathy with Alessi. This is hard. This is a very hard task. As far as how but I wanted to go through the main topics. There were 7 of them that they asked the witness about today. And those 7 topics, I wanted to go through them one by one and talk about, were they successful? How effective was this? Now, the first topic was that the witness did not know there was glass on the bumper, the glass found on the bumper of Karen Reed's car was concluded by a Commonwealth witness, somebody in the Massachusetts State Police, that glass didn't match anything else at the scene. In other words, John O'Keefe was holding a glass in his cup, and it had some part of it broken out, but the glass on the bumper did not match that glass. And the glass on the bumper didn't match anything with the taillight. So it was totally unclear where exactly this glass on the bumper came from. Now, that gives the defense a lot to run with, because they, of course, say that Trooper Proctor was busy planting evidence, that he was trying to plant enough evidence so that Karen Reed could be charged and convicted with the murder of her boyfriend. And that the reason he did that was because he wanted to protect the people inside 34 Fairview. The home was owned by a Massachusetts State Police officer. And so the Karen Reed's team says all of this was a setup to protect those people. And one way you know that is here, glass mysteriously appears on the bumper, and it comes from nowhere. They planted that, and it didn't have anything to do with whether or not she was guilty, or whether anything related to the scene, for that matter. So this witness, Dr. Welcher, did not realize, apparently, that a Commonwealth witness has now admitted that the glass on the bumper doesn't match anything at the scene. He didn't know that. And that's, as I said, important because it does feed the defense argument. So it's a very good cross-examination topic, especially because he doesn't know that. But this witness is so polished that it is really difficult to pin him down on it. And I don't think it ended up having the impact that you would expect. So let's go ahead and play a little more.
Reach a conclusion on whether the glass on the bumper came from the drinking glass that you assert Mr. O'Keefe was holding at the time of the alleged impact.
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
You have no basis, as you sit here today, to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene, so I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
And here's why this is so effective as an expert witness and so difficult to cross. Is because the witness is walking into a trap. I mean, he doesn't know about this, and a less cautious witness would have said, oh, it's probably the drinking glass, or maybe it came from the taillight, offered some suggestions, but he doesn't do that. He doesn't go out on a limb. He's very cautious about exactly what he says.
You sit here today, it's your testimony. You don't know whether in any of the reports of the Massachusetts State Police, there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Assume that there has been testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from, but we still have a whole bunch of other elements. So I don't think it would affect the end results.
Doesn't that, at least in part, contradict your hypothesis as to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview?
So if you recall on my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
You could.
Which is probably what the jury is thinking too. Where did this glass come from? Because it really shouldn't be there. If it doesn't relate to anything from the scene, why was this glass sitting on Karen Reed's bumper? It's difficult to explain. It's a problem, but he doesn't throw himself into the position of having to try to explain it when he has no background to do that and no evidence to do that. So Alessi is sort of left with just suggesting that maybe the witness should have at least asked for it, should have said, hey, has there been any testing on this glass? Can you tell me about what the results were?
Have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just, has there been testing, and if so, what's the results?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
And that is as close as he got to sort of breaking today. Well, apparently I did miss something. And that was as close as it got. I think because of the fact that this particular witness didn't know there was a report, I don't really think there was a lot of responsibility on him to go out and ask, is there something I don't know about? But this was a mistake by the Commonwealth not to have him completely prepared with every single report. So that was an oversight by them. I just think it ended up not being as effective as the Commonwealth, as the defense was hoping. Now, and I see some questions over in the chat. I will say, Megan, thank you so much for your super chat, and I'll save that for the end when we do our questions. That's a great question. Asian Posh has been a member for 9 months. Thank you very much. And is fully believing the reasonable doubt. Marlon, who has a brand new dog and probably has a dog on the brain, is telling us, woof, woof. We are glad to have you, Marlon. And Mama Pinks are our 2 moderators, and so grateful to have them. Mr. Wu wants to know why this expert did not do a German Shepherd reenactment. I think that would be because that would be for the other side. He would not have ever wanted to do that but that's pretty funny. I'm trying to picture how that would go. He did a very unusual reenactment, the blue paint one that we're going to talk about some tonight. I think it was, I think it had a lot of impact in terms of showing the jury the possibilities. So we'll talk about that. All right. And so let's take a look at point number 2 that they talked about with the witness, that Alessi went over with the witness. Point number 2, the defense argues that the photographs that this witness took, Dr. Welcher took, when he was doing a touch test, I guess you would call it, essentially what he was doing. Remember that Karen Reed pulled out of the garage, backed out of the garage the morning after John O'Keefe didn't show up. After she had left him at that party at 34 Fairview, she went out to look for him. She backs out of the garage, and you can see from a video, a ring camera video right there at John O'Keefe's house where she had spent the evening, that she backs out and you can see it tap, touch, hit a vehicle right behind her. John O'Keefe had parked his car right back there so she could park in the garage, and you can see her car hits it, impacts it, it moves a little bit. So one of the questions is, if she is hitting that, maybe that's where her taillight got cracked. Maybe it was not when she hit John O'Keefe the night before out in front of 34 Fairview. That's the Commonwealth argument. But the defense says that's not when it happened. Her taillight got cracked that morning when she backed out. So what this witness has done is he has backed 2 cars like that together. And he says when you put those 2 together, you can see that it would be impossible for them to ever hit, or at least lightly tap. It'd have to be a real crash to break just a taillight. There would have to be a lot more damage, because where the cars would naturally touch is at a different location. The way he did that was something called photogrammetry. And to kind of give you an explanation of what photogrammetry is, because it's going to be real important to understand that in just a minute. That's where you take photographs and a photograph of an event or something in the past, and you lay it on top of something in the present to kind of find out more about how big things were and exactly where they were. What I mean by that is, let's say you have, and we'll take this case, you've got 2 cars that came together. You can take a look at what was in that original photograph, and you can say, okay, over here is a pole, And over here is a basketball goal. And right back there is a wall. And you can triangulate, make sure you have them together. It's basically nothing more than if you have one picture, say, take your hand like this, and you put your other hand and you line them up. That's all you're doing. You're just lining it up. So, okay, I've got it. Is that exactly right? Yep, there it is. And you make sure that the post lines up with the post, the basketball goal lines up with the basketball goal, the wall lines up with the wall. So those are permanent things, and you make sure your picture lines up with that. That's what he did. So he said, okay, I can line this up. I've got a picture from the video of Karen Reed's vehicle hitting John O'Keefe's vehicle. I can line them up and make sure I have it exactly right. Now, the defense argues that the photographs show, well, actually, Karen Reed's vehicle would have hit John O'Keefe's vehicle. The witness says, no, you've got it all wrong. Here's how that went.
This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind the area. Keep in mind the angle, the Lexus is angled off to the left. So the area that you see here is actually, in this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it.
It's in contact, isn't it, sir?
It's very close. It's probably within an inch of being in contact. Yes.
So he says, look, these are not actually ever going to hit in just a light impact. It would take something more substantial, and you would see crush on the vehicles in other locations. So I've proven, says this witness, that this would never happen, that the way they line up, the tail light could not have been cracked at that moment when she pulled backwards, when she and tapped John O'Keefe's car. So point number 3 is that they talk about is that there is a jut outward on the vehicle, and they argue, the defense does, that this witness didn't take that into account. When he lined the two vehicles up, he left out part. Here's how that testimony went.
So I'm putting this up because I want to show an actual photograph of that tail light, and I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? Do you see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back to the depiction we were just looking at, and that depiction doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But
can't see them.
Hold on a second. I wasn't finished. But
Sir.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you? The jutting out that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see on the side of that taillight because it's on the side I can't see. It's being blocked.
That's not a
So,
3D.
I mean, do you see how difficult it is to cross-examine a witness like this? Because there's sort of a polished explanation or answer for pretty much everything. So what Dr. Welcher is saying is, look, you just can't see it, not because we cut it out or we pretended it wasn't there. You can't see it because it's behind something else. And so he's able to account for that. And it's a very difficult cross-examination point. Now, there was an interesting question about whether the Commonwealth had photoshopped some images. The witness was absolutely adamant that it had not happened.
That's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that tail light is a 3D image.
That absolutely is a 3D image. The way you can tell is when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse. Let's, Mr. Woke, zero in on the content. Yeah. There's grain on that tail light, in the tail light. That's a 3D image of the tail light, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That tail light is a 3D image, and one of the ways you can tell is because it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No,
Okay.
thank you. I would like to go to the bumper. Do you see any the predominance of any grainy image on the bumper?
There's a little bit. So, for example, when you get near edges, it has a hard time with edges.
I'm sorry, the bumper cover. Do you see?
Yeah, I see graininess.
Your testimony is that is a 3D image, not a Photoshopped step bumper cover. Is that correct?
So we have mapped the color over the 3D scans. We used 2 separate scanners. If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the bumper cover, not the taillight.
Okay, I'm explaining the process.
I'm just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your
Absolutely.
And Dr. Welch, we're going to ask you to
Okay, let's stop right there. So he is very adamant, as you can see, that there was absolutely no photoshopping and that the pictures that were shown were the result of overlaying a color on it, but had nothing to do with photoshopping, that instead these were actual 3D images generated. And so that is what he says is the case. And there's really not any effective way to cross-examine on that. That's simply his statement. That is his testimony about what happened. Now, I would not be at all surprised if what happens is that they bring in their experts and their experts say something different. Their experts say, yeah, this is clearly Photoshopped, and I think that because of this, this, and this. In fact, a lot of times the expert witness battles just have to do with it's a battle of the experts. The attorneys are involved. I'm not saying they're not relevant or not important, but they're just it's a back and forth really in a lot of ways between the experts. So, and both the experts may prepare questions for the other side's expert, and they may even prepare their own because the attorneys are a little bit outside of their element. They don't know the area as well. And in this particular case, I would not be at all surprised to see the experts for the defense bringing in various points that relate to what you have seen Alessi cross-examine on. So they may fill it in by saying, we think that that's a Photoshop. We don't think it's a 3D model. We believe that they should have used photogrammetry and calibrated, because you're going to hear a little bit in a minute about where the location of the Ring camera was and whether it had changed and whether or not there were some differences. So although Alessi, I don't think, made a lot of headway with this witness, that's not the end of it, because we're going to hear all of this again from the defense experts, and those defense experts are going to say that what you've just heard from Dr. Welcher is false. That's kind of how it works. I've been pretty clear earlier that I don't think that this particular system is working right now in our courts very well. I think juries end up more confused than they were before, because you have one expert who comes in and says, I'm fully qualified, I'm trained, I've been to the best possible schools, and I believe X. And then you have the expert from the other side come in and say, I am fully trained, I have done all of the work, and I have been to the very best schools, and I believe not X. And I think the jury is left, well, how do I know? I have no way of knowing. And so juries end up making decisions on the basis of things that aren't really related to the science, which is exactly what the experts were supposed to stop. So the jury will be looking at, well, okay, which of the experts seemed like maybe they'd done more work or seemed more persuasive or nicer or I liked. And a lot of the decision making now doesn't really relate to exactly what the expert witness is saying, because I think the jury honestly can't do that. So, slight rant and aside on that. There were some dramatic moments today between Alessi and the witness. I wanted to go over a couple of those and talk a little bit about those. Yesterday, there were several times issues where Dr. Welcher had his computer open and was looking through his files or through his computer, when technically a witness should not be doing that. I've told you that I think experts should be allowed to look at their reports and files, but in any event, that is in general the rule, that witnesses are supposed to testify from what they remember and then refresh their recollection from documents rather than read from them. There are a lot of good reasons for that, particularly with non-expert witnesses. But in this particular case, Dr. Welcher was looking at some things, and it became kind of a thing where several times there was a discussion about it. So, but early on in the day before they even got started, Alessi made this comment.
Turn on your computer yet.
Okey-dokey.
Thank you.
And Your Honor,
So, and it's hard to hear, but what the judges just said is, we're going to ask you to not turn on your computer yet. She's saying that to the witness, but very quietly.
I could, smartwatches that are receiving text messages during his direct, if we can make sure that that does not occur.
Get my email number one.
Okay, or just don't look at your watch.
Okay.
Okay.
Thank you, Your Honor.
So we took
So he makes the comment that let's make sure, and there's a little bit of his words that get lost, but smartwatches that there are no, is sort of what he's saying, smartwatches that are receiving text messages during his direct. Sort of insinuating, I think, to the jury that maybe these smartwatches are something that he would be getting answers on. I would have preferred he not do that. I felt like it was a little too aggressive, because that wasn't the issue yesterday. It wasn't him getting messages on his watch. The issue was he was trying to look at his file, and the judge didn't want him to do that. He wasn't supposed to do that. So, but this particular thing, as far as I noticed yesterday, wasn't an issue. So it seems more like it was meant to kind of attract the jury's attention, remind them of what had happened the day before, and just in general to make Dr. Welcher look bad. But it doesn't really make a lot of sense to me, because who is there to send him messages? This is the best witness that the Commonwealth could find. They're paying him to be there because they believe he's going to be a good witness and going to be professional. So I don't really think there's anyone out there who could rescue him and send him a text message when he doesn't know how to answer a question. So I don't really picture that even being likely. And then here was another testy exchange.
I'm sorry, we took
Sir,
the
please
vehicles.
don't interrupt.
Hold on.
Your Honor, he keeps referencing my hand and saying I'm doing something when I'm not, and I think that's distracting to the jury. I'm not interrupting him.
Hold on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing something.
Mr. Alessi, please.
All right.
Go ahead, finish the answer, Dr. Welcher.
Again, in the photogrammetric analysis, I showed the video.
All right, we'll stop there. And actually, I'm going to pull that out. And okay, add this. All right. So, and I wanted to go ahead. That all came during the first unit of time. So now I'm going to move to the second unit with points 5, 6, and 7 that they asked this witness about. But in this particular exchange, it just got really testy, and I fully relate and understand to that, because what Alessi is doing is very difficult and very frustrating. This is someone who's skilled at what they do, and it's difficult to pin him down. And I think that just showed in how he kind of reacted, Alessi did, to all of this. I can certainly understand and relate. The problem is, you don't know what the jury is taking away from this. You don't know if the jury is thinking to, wow, he's being really mean to this poor Dr. Welcher. You just don't know. I mean, I think many people, because they know a lot about the case, and as I see in the comments, I would say the majority of people have sort of taken the side that they believe Karen Reed is being framed, that she is not guilty. But we don't know that the jury believes that at all. And it can be, so you don't know how the jury is going to react. So that's one of the reasons why, if you can avoid that, you definitely want to. I thought it was, it's risky, because you just don't know where the jury is in terms of what they think about Dr. Welcher. So let me go backwards to Irie asks about whether or not Higgins, I'm not going to put this on the screen, but thank you very much for your super chat, about whether Brian Higgins was framing her, and that he felt like Hank playing Karen Reed's words right before the end of the case was brilliant. I think his I think Hank Brennan, the attorney for the Commonwealth's use of those clips of Karen Reed talking to the media has been extremely effective. Very well done. Genji Probs has been a member for a year. That is awesome. We are so glad. Thank you, Genji Probs. And Heimster is talking about photogrammetry and the need for a proper camera that's calibrated and the ring camera not being sufficient. We're going to get a little bit into that in one of the next points. In fact, let's go ahead and add that to the screen and let's get started. Now, as I said, I felt like Alessi got, a few kind of glancing blows, which is really about all you can expect with a witness like this. So I thought point 5 was really important. I thought it was probably the most important point he made, that the Lexus SUV has a hydraulic system that could raise the vehicle 3 inches, lower it 2 inches for a total range of 5. And Dr. Welcher knew about that, but he did not take that into account. Here's what came out, and then we'll talk about whether that matters.
Yeah, that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system on the Lexus?
No, again, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches. At one point in time I measured it. I don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume that the manual, as well as other informations, support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's the basis for the 5. What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr. O'Keefe? If it was even possible, what did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus to match that.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document at all?
Yes.
Where?
Slide 107. We matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
So he makes the argument that maybe I didn't know exactly how big the distance was that this could raise or lower, but we matched it to the actual condition it was in when it was at the station, when it was impounded from Karen Reed, when it was taken into the station. So we know it matched. Now, Alessi has a pretty good argument about this because that's still going to be imperfect, because when you see this measurement being done on the screen, that was more than a day later, a couple of days later. By then, multiple people have driven the vehicle. Maybe it's not the same.
What was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29, 2022, while at One Meadows and colliding with the Chevy Traverse? What was the suspension height then?
We assumed it was the same as when it was at the Canton Police Department.
Exactly. You assumed, but there's no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the taillight on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Do you know whether the suspension system locks when there is testing of the infotainment system?
Whether the suspensions, I don't know.
So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
So remember I told you about how that you will be setting your expert up to answer some of the things you're going to ask the other side's experts. So what you just heard, that infotainment question that got dropped in there, hey, if you test the infotainment system, which did happen in this case, the Canton police did, if you test that, does that lock the suspension system? Because if it did, obviously it might lock it in a particular position, so it wouldn't be the same height, wouldn't be acting the same way that it was on the night when John O'Keefe was found lying in the snow the next morning. So that question you heard dropped in there, that's exactly the kind of thing I'm talking about. That's a little Easter egg dropped right in there, left for the defense expert to pick up. I guarantee you we're going to hear that the infotainment system locks it. Now, this witness didn't know anything about it, but I believe one of their ARCA experts is going to talk about that. So we will find that out soon. I don't know whether the testing that was done on the infotainment system happened in that first 2 days and would have locked it at that time. So I don't know whether that will truly affect anything that this witness has to say. But another issue is, what does this really affect? Does this really make a difference, what he said? And I think the answer is not really. And here's why. The only test that the reason it mattered where the vehicle was, how high it was, is because there's a spoiler on the back, and John O'Keefe had a cut on one of his eyes. The defense says that's because somebody inside 34 Fairview hit him. But the Commonwealth says, no, that's because he was hit by the car and maybe he cut his eye on the spoiler. It's possible. But it's not as if this expert, Dr. Welcher, has any sort of specific testing that shows exactly how John O'Keefe's body moved. He just said, well, maybe he was leaning over. Maybe he was standing up. Maybe I don't. He doesn't have any idea. He's just saying, here, it could have happened on this. So he's already not paying any attention to how high or low the vehicle is. It's already not very important to him. Now, it might have been relevant in the photogrammetry, but since he lined the vehicles up based on where they were, it shouldn't be. So I don't know if in the end that will actually have a lot to do with what his testimony is. So now point number 6 was that the Lexus did not apparently detect the collision between Karen Reed's and John O'Keefe's car in the early morning. Now, we know she backed out of the garage, that she tapped or hit John O'Keefe's car, and apparently her car registered nothing. And so the defense says, well, how is that? If the car missed that, how do we know what the car records or doesn't record? And the witness said, well, that's just normal. Dr. Welcher said that's normal because the tech stream is never designed to record collisions. Instead, it's designed to record things like acceleration and braking.
There was a collision between Ms. Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided. They made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No. The impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions
let me stop. So I want to move now into point 7. And in fact, we'll bat this up so you can hear all of what Brennan says. So the 7th topic that got discussed with Dr. Welcher today was the fact that the Ring camera that had recorded that early morning tap hit between Karen Reed's Lexus SUV and John O'Keefe's SUV parked out in the driveway, that Ring camera had been changed out. There had been a question earlier in the testimony about, didn't you change that? And I kind of wondered where they were going with that. But what the point of the defense is, if the Ring camera's been replaced and it also had a mobile arm that could be adjusted and moved around, then how do you know that you've lined up the camera properly? You don't know exactly where the camera was at the time of the event. And the witness says that's not the way that all of this works. That I, the witness, Dr. Welcher, I knew that it had been replaced. I did account for that. It wouldn't have mattered. Here's what he told Brennan on redirect.
Camera was replaced. Does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions relative to that touching between the cars?
Absolutely not. It would have shown up as increased error when we overlaid the point clouds onto the photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
So there was one sort of funny dig that Hank Brennan got in on this redirect examination of the witness. So there were communications between ARCA and Alan Jackson, one of the attorneys for Karen Reed, that were done on an app called Signal that allows messages to be encrypted. Now, the Commonwealth is hot under the collar about this because that means they can't see those messages. So any messages that might have been turned over are now no longer available to be seen. And so Hank Brennan got in one question before the judge shut him down.
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
No, I don't have any of those.
So the form of the question, ask it differently.
When you were communicating with members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
Objection, scope, Your Honor.
I'm going to allow it.
No, I mean, I don't even know what that is.
Would you ever use an encrypted app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Objection, Your Honor.
Sustained.
Okay, so that was the last he got. So as I mentioned, one of the things that the attorneys are going to do to try to go after these expert witnesses, because they are so difficult to cross-examine, they're really good at parrying all the questions. So one of the things they'll go at is other things that would show credibility. That the resume of the witness who was so brutally cross-examined by Alessi earlier in the trial, that's a great example of that. Does that have to do with the work he did in this case? No, not directly, but it has to do with his credibility, what people think about him, and whether or not people believe they can trust him, including the jury. And so that's the sort of thing that Hank Brennan will use on cross-examination. Look, our experts don't communicate by encrypted app. What are you doing? That's the implication he wants to make. So the Commonwealth then ended as they began with a clip of Karen Reed speaking. This has been probably the surprise of the trial so far, is how effectively the Commonwealth has been able to weave these in. It especially worked at the beginning of the trial. There haven't been as many recently, but they held off. This one here is the very last thing the jury heard as the Commonwealth's case rested.
Commonwealth moves to introduce and play clip 26.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Your Honor, the Commonwealth rests.
I mean, that's it. That's the end of what they hear. Super effective, I think. Let me remove that and talk to y'all a little bit more. I think that was a very effective way to end it. We are about to get started on the defense case. So I want to go to Megan's question that she asked at the very beginning. Please tell us what direction you think the defense will take. I appreciate that you're interested in my thoughts. I'm really interested to find out what they're going to do as well. We've been told they're going to have many more witnesses. Last time they had 6. We've been told they're going to have more. We don't know a lot about exactly what they're going to do. We know for sure that they plan to bring the ARCA witnesses. We know for sure that they plan to bring the dog bite expert witness. So those witnesses we know we'll hear from, but we think there may be more. When she left court today, Karen Reed was asked, are you going to be able to get Trooper Paul's report in, the work that he did, without calling him? And she said, apparently not. And then the reporter followed up with the question, well, are you going to call Trooper Paul? And she said, I believe for that one, she said TBD, to be decided. They asked her, are you going to testify? She said TBD. And they asked her about another witness. Oh, Brian Higgins, I think. Are you going to call Brian Higgins? No, it was Proctor. It was Proctor they asked about. And she said TBD. So it may well be that they haven't fully made those decisions yet. They probably have a lot of these people under subpoena so they can go as needed. We've been told they're expecting about a week and a half, something along that order, in terms of how long it will take the defense to present its case. So as far as the direction, I think they're going to probably follow what they've done so far. What they have done so far is really lean into the question of what they are doing, the Commonwealth is doing, to prove that she actually hit John O'Keefe. They're leaning very heavily into causation. Like, what's the proof that there was a car wreck? Because if there's not a car wreck, if there's not an impact between Karen's car and John O'Keefe, then she's not guilty. That's actually absolutely has to be the decision that's made. So they've leaned heavily into that. They've definitely talked about third-party culprit, but they have done less with trying to prove that conspiracy like they did last time. I think, frankly, that it's more effective to go really hard on the issue of what proof the Commonwealth has, because this isn't an open and shut case. So I think that's a pretty good argument. And they, meanwhile, have seeded the idea that, oh, there are other people who might have done that. So I expect them, based on what we've seen so far, to pretty much lean heavily into that causation and the ARCA experts. Okay, so great question. Thank you. And let's see who else. So Heimster was talking about the Ring camera and the need for a proper camera that's calibrated. Heimster, I would not claim to be an expert in any way in photogrammetry. I do not even pretend to be an expert in that. I thought that they could line it. They may need, when they retake the pictures, a pretty fancy camera. But I thought for the rest of it, it was just a matter of lining it up. So your camera has to be able to completely line up with what the other one is. In this particular case, they weren't using a camera. They were using 3D imaging. So But other than that, I am completely unable to go there, Heim, sir. I don't know. You may be absolutely right. I can't answer that. All right. Genji Probs is pointing out something. It feels icky when the state or Commonwealth spends $400,000 to take away one person's freedom. I do want to throw out one thing. I believe that they said that the $40,000 is how much they paid the experts, which is not at all uncommon, and that the rest was used to buy exemplar vehicles, which will then be, or one or more, which will be sold, and then the Commonwealth will only end up paying the difference. So it won't be that much. While they had to outlay that amount, they will get part of that back. So I just want to throw that out there. But I understand your point. Your point is when the Commonwealth spends a lot of money, but then that's what all prosecutions are, because the prosecutor, all of those people who come to testify for the Massachusetts State Police, for the Canton Police, those are all people paid by the state or by the local government, and they're brought in to deal with the question of this person's freedom. But there is a sort of a little bit of ickiness around that. I totally understand that. I think the only thing kind of worse than that is when the defendant doesn't have access to anything similar to that. So the prosecution is paying all this money and the defense isn't able to pay that money because the person doesn't have the wealth to counter it. I mean, Karen Reed has an amazing array of attorneys and experts lined up. This is not all that common. So it's a very fortunate thing for her. Zero patience. Thank you so much. I appreciate that. Tanya Vincent is a Hank Brennan fan, that he is doing, is a great storyteller. The jury can disagree, but it's clear. In other words, you can understand the story. Thank you, Tanya. I appreciate your comment. And is she's now suggesting that Hank is trolling. So Hank Brennan has paid her to make these comments. I guess she's joking. Thank you, Tanya. I appreciate your comments and your super chats. And Bleeding Green in Texas is saying, I'm not sure if this is me being biased, but I feel like Brennan sounds too defensive or confrontational on redirect. Bleeding Green, it's not just you. It's really difficult when you're on one side or the other to fairly judge what's happening. It just is. And so that's one of the reasons why I've tried really hard not to state my position on some of these cases, because I want to present it fairly and to not take one side or to feel like I have to defend that side. And that can be really difficult. I mean, it really can. It's especially difficult in this case, where I would say the majority of people have reached a conclusion. They feel really strongly one way or the other. So it's difficult, to take a position where you just are going to try to remain very neutral. But as far as Brennan sounding defensive or confrontational, to me, today, Alessi sounded much more that way. He sounded much, he would raise his voice sometimes and would really get into it. I don't think any of the attorneys have gone too far overboard in this. It's a natural part of the process as people get pumped up and dealing with just being the attorney and being there in the adrenaline. It's all kind of a natural process. I feel like they've all done okay on that. So I didn't feel like he was too defensive, too confrontational, but we'll see. We do know that from one of the voir dires that he can actually cross-examine. I'm looking forward, because last time we didn't get cross-examination very effectively done by the Commonwealth. So we will see what happens this time around. Okay, so let's look at whether or not you have any questions. If you do, put your questions in the chat with some question marks at the beginning, and I will try to answer a few. And don't forget to put the question marks at the beginning, because that's my best shot of being able to find your question in the chat. By the way, would you mind hitting the like button? That'll really help with the YouTube algorithm. I would appreciate it. And if you haven't subscribed, join us. We would love to have you. You can help push us toward 200,000 subscribers. We're getting ever so close. So please join us. All right, so I'm looking for, I'm looking for the questions. And as I said, if you would put your question marks at the beginning, that'll really help. So, and this from Baba D is saying, wouldn't dog bites leave bruising? Also, but no bruising. If already unalive, was there another animal outside that night trying to wake or help? So the whole issue of the injuries to John O'Keefe's arm has become one of the most important and most hotly contested points of the entire case. The witness that we just talked about, Dr. Welcher, did a test using blue paint. He coated the back of the taillight that was broken and coated it with blue paint, and then he rolled past it and showed that his arm had blue paint. It was on the thumbnail I used, so but it's like right through here. Well, that's exactly where the injuries to John O'Keefe's arm were. And, you know, remember when I said yesterday that I hoped Brennan would pick up on the question of where the marks were within the blue paint? He did not do that. So the witness is gone, and he did not ask him about that. So the jury will not have that. I was wanting to know. One of the questions from Alessi had been, well, shouldn't some of the marks should be here and some of the marks should be here, and they aren't like that. And the witness said, no, you can see from what I did, you can see from the picture that, and then it got, Alessi said, well, that's not my question. And then Brennan didn't come back to it. So I'm kind of bummed about that. I was really looking forward to that. So back to, I've gone on a tangent. Baba D's question, wouldn't dog bites leave bruising also? He did not have bruising. He had lots of scratches on him. So one of the defense points is, well, if he had actually been in an accident, a wreck, had been hit by a car at 4 miles per hour, moving backwards, I mean, that's a pretty big lick. He'd have broken bones. He'd have some bruising, and he did not. So why? And so I think Baba D is saying, well, if this is dog bites or scratches, maybe that would bruise also. But I don't know the answer. I can see where both could cause bruising. The bottom line was both sides are contending something, and there is a missing piece in there, which is bruising. Now, you could, I think, have a car wreck, have a dog bite, and not have bruising, just have scratches. But I don't know that. I don't think we've really gotten a definitive answer on the no bruising if somebody is already unalived. I don't think we know that. I don't know that a witness has stated that yet. I do think it's the case that, especially since he was so cold, I can see a possibility that maybe there wouldn't be bruising because of that, but I don't know the answer to that. Very important questions, and we may find more answers on this coming up. All right, so I'm looking for the question marks at the beginning. Is the Commonwealth trying to get the ARCA testimony thrown out? Well, they've tried various ways, but I don't think they have succeeded. They've tried various to get pieces of it thrown out or to get more information from them. I don't think it's going to be thrown out. I think we are going to hear from the ARCA witnesses. I think that's going to happen. Lindsay Bay is asking, will Proctor and Higgins be called? And that is not only unknown to us, but according to Karen Reed, unknown to the defense. She was asked about Proctor. She wasn't asked about Higgins. But I don't think they would bring Higgins. I just don't. They've already got all of the text messages in. I don't know what more he's going to say for them. And there are some things he could say, like, I was inside the house and no one came in, that maybe would be harmful to Karen Reed. So I can see her not calling him. I can't really figure out exactly why she would not call Trooper Paul. I don't remember all of the things he testified to. So maybe there were some things in what he said that were negative for her that she doesn't want to reinforce to the jury. And now Michelle asking, which witness do you think the defense will call first? She said today, Matt De Silva. And I do not remember Matt De Silva, so I don't know who that is. But if you know, put that in the chat, because I'm kind of curious. I did some Google searching, Matt De Silva, Karen Reed, Matt De Silva expert. I couldn't find it, so I don't know. I don't know who that is, but that's apparently their first witness. Do you think Karen's team is astroturfing? I can't believe any reasonable jury could believe the frame theory. Do you think the chats are infiltrated? Cat Love says, okay. So I don't know what astroturfing means. I'm sorry, I'm terrible with slang and stuff. But I'll go with the second question is, her point, I think, is could anyone believe this frame theory? Is that possible? I think they certainly could. I think we have tons of people in our chat who believe that. I think we have tons of people on the internet who believe that. Do I think everybody out there is somebody infiltrated? I mean, no, I think there are many, many people who believe that Karen Read is being framed and who believe that it was a cover-up done by the police to protect other police. I think there are a lot of people who believe that. Now, are there also people infiltrating? Absolutely. Probably both are true. All right. MB asking, ask me about my end opinion. I'm trying very hard not to do that, to be as neutral as I can be right now. Juju, do you, I'm missing a word there. The Commonwealth didn't call Proctor so Hank could cross him and make it seem like they don't agree with his actions. That's an interesting question. And that is a huge consideration for Karen Read's team as they consider whether they are going to call Trooper Proctor and Trooper Paul, is the fact that they, being the ones calling the witness, will have the witness on direct examination unless there's a ruling that this witness is hostile to them. They might get one with Proctor. They probably would not get one with Trooper Paul because he doesn't have any kind of animus other than his experience at being cross-examined last time. So I think, but that's a pretty interesting point, but by crossing him, they could make it clear that they do disagree with his actions. I don't think they would have been helped at all by calling Trooper Proctor. So I mean, running away from it was just as good as anything else. Sue Bass asked about why has no one tested the reverse security system that will stop the SUV when it's too close to an object. You know, Sue, I would just have to say, if they had a device like that, then if we haven't heard about it yet, I think we will hear about it during the ARCA witness testimony. So I think that would be coming if there's anything like that. I do think this witness probably would have mentioned it if there had been something and some explanation for it. Like while there is such a thing, it didn't turn on, or some explanation. But it would seem like there would be something like that. It's kind of odd that there wasn't. All right. Janet Studdard has been a member for 15 months. Janet, that is awesome. Thank you so much. And is suggesting that states should have a set amount for experts. And you may remember in the Delphi case we covered, they had to petition the court to get some money freed up so they could get experts, because Richard Allen did not have the money to pay for experts. And so there is a fund that can be used for defense experts. And the other one is something, I'm pretty sure that in this particular case, Lally had to go back to the board in Canton and ask for additional money for trying the case and for what they were doing. Not just experts, but everything related to how much the case was costing. All right. And Tanya is saying that Hank's team found Chloe and has a mold of her mouth. Stay tuned for rebuttals. That is something that we've heard about, that there is a mold of Chloe's mouth that it wouldn't match or wouldn't fit, but not a lot is known about that yet. So I'm looking forward to finding out what the evidence is as we move forward. Thank you, Tanya. Bleeding Green in Texas having a strong opinion on Alessi sounding whiny today. So I do think that one question when he said, you know, he's doing my hand motion. Like, oh, come on. I wasn't even sure what he meant. The witness had said, wait, and held up his hand, but it didn't seem to me that he was mocking anything Alessi had done. He was saying, let me continue with my answer. I haven't finished yet. But in any event, I think Alessi did a phenomenal job. He's an incredible lawyer. He did such a good job with witness after witness. So there's no shade on Alessi. He's done a phenomenal job. He really has. All right. Penelope just has questions. That's pretty accurate in this case, actually, Penelope. Daniel asking, how long do you think the defense case will last and the rebuttal? I think that the defense case, according to Karen Read today, when she was leaving the courthouse, she figured a week and a half, something along those lines. And that's not far off what it was last time. So that would make sense. They have a few more witnesses this time around. As far as the rebuttal, I think it would be more because of the fact that this time around, the Commonwealth is ready, just like what Tanya mentioned about Chloe and the dog bite, which, by the way, I'm not sure they're going to be able to get that in. But if they do get that in, they got some things ready for rebuttal that they want to be able to use. So I think that they will have, it'll be a little bit more time. A lot of times rebuttal is very brief, not much left to present. I think there may be some things this time that the Commonwealth has not saved really, like they didn't use them, but it wasn't yet appropriate until the defense made an argument and then they could do it in response. Spicy Cat says, how can somebody reverse with the speed of 22 miles per hour over 80 feet while it is snowing in the dark? That's always been a good question. That seems really hard. And that's a long way to go. That is a long way to go. I remember a reenactment done by one of the news stations, and I thought, that is a long way to go. Jenny Hartman, why were they allowed to change the time to match the car and phone? So what they were trying to do was they had two different clocks, and we went through a timeline. Jenny, you would probably enjoy that video. It was 2 nights ago, I think. And I did a timeline where I overlaid what they were saying before and what they were saying after. And essentially what they did was they said, look, we've got two different clocks and they don't match in time, but they're both keeping time. So what we're going to do is just pick something that connects the two, because we know they both recorded this one event. We know they recorded this. We're going to sync them up, and then we can tell what the time will be. So they just believe that it's syncing a clock, that it's nothing more exciting than that. S. Mickey's Mouse says, or Smicky's Mouse, I don't know which it is. Does the family have to pay when the state gets expensive expert witnesses outside the norm? No, but the taxpayers do. This is something that would get billed to the state. It would be billed within the prosecutor's office. There may be a pool they pull from for something like that, but it isn't paid by the family. On the other hand, the family is expected, if they have money, to cover whatever the cost of the defense is. That isn't something that is provided for unless the person doesn't have the money to do it. In Karen Reed's case, her family and she are actually paying for this defense. And so they are paying their own experts. They are coming up with the money to do that. All right. Ooh, 8:13. My goodness. Okay. So I'm looking for the question marks at the beginning. Rose, wouldn't the airbag engage? Rose, the airbags are set to engage in a frontal collision if certain parts of the vehicle are hit, in a side collision if certain parts are hit, and in some cases, I don't know if cars have rear ones or not, but they may. But they're very specific. There are triggers on the car that get hit. I did a lot of product liability. That's how I know this. So that get hit in a crash. In a big crash, they're often going to be hit. But sometimes you get a hit that just misses one of those trigger points, and so you don't get an airbag engagement. It doesn't happen. So the fact that the taillight itself was out probably means that there's not going to be any kind of engagement. There's not going to be a sensor right in that area, which would cause the airbag to deploy. The airbag is really to protect the driver or the passengers, and hitting somebody, a pedestrian, in with your taillight, that's not going to really put anyone inside the vehicle at risk. And so that may be one of the reasons it didn't. Pamela Jean, have they determined the amount of force it would take for an elbow or an arm to break the light on the Lexus taillight? I don't think we got a definitive answer on that. We got some measurements that he talked about how much pounds force would have been exerted on the arm, on the hand. Frankly, the testimony yesterday on the cross-examination was a little bit confusing on that. So it was either 300 or 400 pounds or 2,100 pounds. And either way, nothing broke. It's kind of the way I heard it in the end. CCFF is asking me if I think with hindsight that a different attorney with a different style would have been a better option. I'm new to this case. Loved Alessi Cross. All the despicable so far, this not so. So I think CC is saying maybe in hindsight, should they put a different attorney on this? It would have been frustrating for anybody. Alessi has done a fantastic job. He's an incredible attorney. So just no shade. I did feel like those 2 points I pointed out would have been better if he had not said those, but he did a great job. This is a very difficult witness to cross, and I wanted to be honest with you about that because it's very easy to say, oh, well, most people will like this or want you to say this. And what good am I to you if that's what I do? So I do want to be honest and fair with y'all. So, all right, well, I will see you all tomorrow night at 7 p.m. I'll look forward to it. Don't forget to hit the like button on your way out and to subscribe. We would love to have you back.